Anti-dilution, there are many mechanisms. Some of them are Sharia compliant, some of them are not. Now, when anti-dilution is done through the right of first refusal or preemptive rights, basically, when anti-dilution is done through a legal clause that would give the right to the shareholder, to a specific shareholder, to buy additional shares when the company is issuing new shares, or when one partner is selling their shares. So that's the right of first refusal. This is when a partner is selling their shares. Preemptive rights is with the company issuing new shares. So some partners are given the right to purchase these shares first on pro rata basis, meaning that when these shares are offered, they can purchase shares according to what they own, and sometimes even the company has to offer them the amount of shares that would maintain their equity ownership. Let's say I own 5% in a company, and I have this anti-dilution right, the right to purchase shares whenever there's an equity financing, there's a funding round, or there's fundraising. Whenever the company issues new rights that might dilute me, I have the right to purchase shares, ensure that I maintain the 5% ownership. So that is okay, that as long as we don't fix the value and I have the first right, I have priority to purchase shares before others or other partners or other non-partners like third parties, then that is allowed. However, there are other ways to ensure anti-dilution. One of them is the downside protection. Downside protection is also common in startups. Basically, a startup, an investor comes in and requests the company to give them a downside protection, which means that I agree on the value of your company now. Your valuation, let's say, is 10 million or 20 million. I agree on that valuation. However, if in the next funding round, your valuation falls down, I purchased 20% equity in your startup, and we agreed that the valuation is 10 million. However, if the next funding round, your valuation fell down, valuation was lower than 10 million, then I maintain that 10%. You will give me additional equity, you will give me additional shares to maintain that 10% even after the down round, the round where your valuation was lower and I got heavily diluted because your valuation is lower. It's not just you issued new shares, you issued new shares at a lower valuation. Now, in this case, we have three scenarios. The first one is an absolute guarantee. So, I mean, there is no restriction on this clause. There's a downside protection. If the valuation goes down, then we will issue additional shares to maintain your, to give your equity the right. Actually, it's not the, you will take additional equity based on the lower valuation. Let's say the next round, I mean, just to ease the mathematics, the next round was, the pre-money valuation was 5 million. And I have owned previously 10% or 20% in a 10 million valuation company, which means that the company was valued 8 million pre-money. Let's make it 4. So I'll take the double. I'll take 40%. And now I'm ready to get diluted. But however, I gained a higher equity ownership. I hope I didn't confuse with the downside protection. If someone has a question on downside protection, you may ask me from Sharia perspective or even from legal perspective. However, I hope Brother Akhtar will make it even clearer. So if that's absolute guarantee, then it's not allowed because it violates principle number 3, no capital guarantee. If it's, however, because in Sharia we always want to understand why these conditions, why these clauses exist, and we understand this. We know that they're there for the purpose. We understand the startups culture, and we know why these conditions came into or why these clauses came into existence. However, while we acknowledge this, we acknowledge that the way that they deal with these challenges and problems in the startups are not always fully compliant. So sometimes we need to tweak it. So such protection is allowed if the lower valuation was due to negligence of the managers. So because they were negligent or they have breached the terms, they have acted not in good faith. Because of this, the valuation was lower. Then in this case, we might have a downside protection, or we can have a downside protection. Or actually, even without having this condition, you can go to a court that understands law and Sharia, and they can protect you. Another situation when it's based on a misrepresentation. If the founders misrepresented their company in a way that showed that their valuation is higher, in a way that the industry experts understand that this is a misrepresentation. We understand We understand that valuation of startups, it requires a lot of, or it takes a lot of assumption and subjective takes on the startup. That's not misrepresentation. Misrepresentation when you fraudulently represent your company to show that it's higher than it actually is. So in this situation, also a protection or downside protection is allowed.